and welcome to The Week That Was, TIOL's weekly news roundup. Today we bring you news on the novel method adopted by the Trademark Office to reduce the backlog of cases, an antitrust motion against Google in Europe, India's bid to improve the ease of doing business for multinationals with international transactions, and easing withdrawals from the Provident Fund.
There is also news on the grim outlook for the global economy and new guidelines on foreign tax credit. But first, let's hear about the Supreme Court setting a historic precedent against abuse of judicial process.
An aggravated Supreme Court has levied major fines against 3 companies for unscrupulously abusing the judicial process, which could set an important precedent for others. The Supreme Court of India, by its very nomenclature, is meant to deal with vital constitutional issues or questions of law or cases of grave injustice. However, Article 136 of the Indian Constitution grants the Apex Court special discretionary powers to entertain special leave petitions for appeal against any order of any court or tribunal in India. As the Indian Constitution is silent on the kind of cases in which this discretionary power must be exercised, it has become a regular practice by parties to file SLPs against all kinds of orders. As a result, the Supreme Court has been practically working as an ordinary appellate court and not quite the apex constitutional court of the land as originally intended. Consequently, the backlog of cases also in the Supreme Court has mounted and the justice delivery mechanism is badly clogged. In this scenario, enter 3 companies, a German company that purchased the shares of 2 Indian companies, one of which belonged to the powerful RIA Group. These parties were involved in multiple litigations and arbitration relating to the purchase of shares, which dragged on for 18 long years and culminated in the Supreme Court. The company counsels urged the Apex Court to examine every question of fact and law in the huge litigation records. Arguments were advanced for 18 working days, as if the Apex Court was a court of original jurisdiction. The Supreme Court bench, headed by Justice Mr. J. Kelameshwar, observed that the case was a classic example of the abuse of the judicial process by unscrupulous litigants with money power. The conduct of none of the parties of this litigation was wholesome, as each of the parties was guilty of misconduct, having resorted to half-truths, misleading representations, and suppression of facts. The Apex Court imposed a fine of Rs 75 lakhs on these 3 companies for unscrupulously abusing the judicial process. It is high time that the Apex Court used its discretionary powers to entertain SLPs only in exceptional cases to unjam the judicial process. The Labour Ministry might soon pass an order for better payments for contract workers.
The government may soon change the rules to ensure that contract workers get a minimum wage of Rs 10,000 per month. When the Supreme Court directed the government to increase the minimum wage for workers, the government made changes to Rule 25 of the Central Rules of Contract Labour Regulation and Abolition Act. But with Parliament not functioning optimally, this labour law reform could not be cleared. Hence, the government is considering the issue of an executive order to ensure that contract workers get a minimum wage of Rs 10,000 per month. Contractors would be required to register with the Labour Ministry, which would benefit crores of workers across India. New rules on foreign tax credit will bring relief to those who have paid tax in a foreign country.
To make the taxation regime fair and reduce tax disputes, the Central Board of Direct Taxes has introduced a draft framework of foreign tax credit rules which will allow assessees to claim credit for tax paid overseas. These rules will bring relief to companies with foreign income that end up paying taxes in both the countries, as there is no provision for taking credit for such tax under the Income Tax Act. The draft framework will apply when tax is paid in a foreign country and the same income is subject to tax in India. The rules will allow the resident taxpayer to take credit for such tax or claim a deduction on the taxes paid in any foreign country, including those with which India has a double taxation avoidance agreement. Such credit shall be available against the amount of tax, surcharge and cess payable under the Act, including the assessee's MAT liability, but not against any interest, fee or penalty liable to be paid by the taxpayer. Also, no credit shall be allowed on foreign tax being disputed by the taxpayer. The taxpayer shall need to submit specific documents to claim such credit. The government has eased PF withdrawals. The question is Provident Fund an instrument of social security on retirement or to be treated as a savings bank account?
The government has been forced to withdraw with immediate effect the notification tightening Provident Fund withdrawal norms. Following widespread protests from trade unions, the Employees Provident Fund organization has rolled back the February 10 notification restricting the withdrawal of the employer's contribution to the PF corpus until the employee turned 58 years of age. Employees can now withdraw the entire amount from the Provident Fund as per existing provisions of the EPF scheme, including the employer's share of 3.67%. This is the second reversal relating to Provident Fund withdrawal. Earlier, the government was forced to reverse the budget proposal to tax 60% of the PF corpus at the time of withdrawal. The CBDT is set on signing 100 advanced pricing agreements with multinationals this year.
To improve the ease of doing business and resolve transfer pricing disputes with multinationals, the CBDT has set up an ambitious target of signing 100 advanced pricing agreements with multinational companies within this financial year. An advanced pricing agreement or APA helps to resolve disputes because most transfer pricing disputes are connected either with the calculation of profit by the multinational company or profit shifting to the parent company. So, considering the payer's future international transactions, an agreement is signed between the tax authority and a multinational company predetermining the transfer pricing methodology to calculate taxes for a stipulated period of time. With officials already working on 175 cases, the target of 100 APAs seems achievable. In 2015-16, the CBDT had signed 55 APAs, bringing the total number of APAs signed in the last 2 years to 62. Sale of low-cost FMCG products have surprisingly shown amazing growth in Indian villages.
The economic slowdown may have impacted consumer choices in urban India, but the trend in rural India was different. Household consumption of fast-moving consumer goods in rural areas grew at 5.4%, showing twice the growth as compared with urban India in 2015. Data with IMRB, the market research agency, showed that rural consumers go for the right product if available at the right price and in the right pack size. Another reason for this positive growth in rural consumption of non-durables was the optimism for a good monsoon and harvest in the second and third quarters of 2015. With the weather department having predicted an above normal monsoon in 2016, agriculture output and rural demand are expected to show an upturn. Tata Steel goes to court over its trademark application.
India's patent office is in the eye of a storm for the wrong reasons. The Controller General of Patent Design and Trademark, to clear up the backlog of cases, seems to have abandoned nearly 2 lakh applications without sending out the notices to the applicants. One of these applicants was Tata Steel that had applied for an ACE Plus trademark for its service center certification program. Following the abandonment of its proposed trademark without due notice, Tata Steel approached the Delhi High Court along with the Intellectual Property Attorneys Association. The High Court has stayed all the abandoned orders passed between March 20th and April 4th, 2016. and directed the authorities not to pass any new abandonment order without prior notice to the parties. The Trademark Office shall need to find other ways of reducing the pendency. A record number of 150 countries shall sign the Paris Agreement on Climate Change in New York on opening day.
India, along with 149 countries, will sign the Paris Agreement on climate change in New York. This will break the previous record of 119 signatures for an opening day signing of an international agreement. The Environment Minister, Mr. Prakash Javadekar, shall sign the agreement for India at the signature ceremony convened by the Secretary General of the United Nations and expected to be attended by 60 heads of state and governments. The Paris Agreement sets out a legally binding global action plan to limit global warming and avoid dangerous climate change. Adopted by 195 countries, the Paris Agreement shall enter into force in 2020. The government probably killed the hopes of many who want Britain to return the Kohinoor diamond to India, but then quickly took a U-turn.
Opinion in India is divided between those who want Britain to return India's Kohinoor diamond that occupies pride of place in the Tower of London and those who feel it never will. Initially, the centre categorically told the Supreme Court this week that this famous diamond was never stolen. It was gifted to Britain by the Sikh ruler Dilip Singh. Some historians believe that the ruler was tricked into parting with the famous diamond as compensation for the Anglo-Sikh War and the East India Company that gifted it to Queen Victoria. So it must legitimately be returned to India. The Apex Court was hearing a public interest litigation by the NGO named All India Human Rights and Social Justice Front, seeking the return of stolen precious items from India. The court was in a quandary, as dismissing this petition could serve as a negative precedent for return of India's treasures and impede the government's future efforts to reclaim precious artifacts spirited away from India. Foreign countries could cite the decision for rejection of such return claims in the future. Faced with criticism by the Apex Court, the centre quickly backtracked and resolved to make all possible efforts to bring back the Kohinoor diamond in an amicable manner. The Apex Court observed that India was colonized and ruled by several foreign powers, and the government needed to consider all dimensions before filing its affidavit on the official stand on the return of the Kohinoor and other precious items taken out of the country. On this note, we conclude this bulletin of the week that was. Thank you for watching.
You may write us on editor@tiol.in. Have a wonderful weekend.